Hi, good evening, everyone. Suki here. Hope you're having a nice day. Let's wait for 1 or 2 more minutes and we'll start. Hello? Sir. Hope, guys, from people from Chennai, how is the situation there? I'm hearing very frightening news from my friends and family.
It's okay. Not so bad.
Not so bad. So far, so good. Okay, fine, Mazar. But stay safe, please. I mean, the warnings for tomorrow seems to be, frightening a lot of people.
I'm residing near Marina Bridge, but I don't see anything. So like whatever forecast they have proposed, nothing so far.
All right. Okay. Very good. I'm not really keeping well today. I've got a bit of a cold, so excuse me if I had to sneeze or cough in between. I'm just giving a heads up. I think we are good to go. We are 24 people. Let's start, right? So, um, yesterday we did not leave anywhere. We completed the conversations that we're having. So let's go today into the slide deck for the very first time and then start seeing. If you can request people to go on mute, that would be helpful, please. Thank you very much. All right. So, as I said, we will first touch upon the first section, the boring section, right? So, first section has got 3 chapters within it. The very first chapter is in the body of knowledge of CIPPE textbook is Origins and Historical Context of Data Protection Law. This is written by Sian Rutgard. So this is pretty, the first 2 3 topics will be pretty light, and then once we get into the Treaty of Lisbon and other things, this topic is not so very heavy to digest as such, right? But next topic, next chapter, maybe one like that. So we'll quickly go through what's the rationale for data protection, right? So, excuse me. So, we kind of explored the very basics of many things. Why data protection? What is privacy? What is personal data? And all of that we spoke. And I think yesterday we had Satya ask a question: when half of the data is already out, why do I still have to protect it? So all of that, we discussed about balancing, bringing a balance in the ecosystem where a subscriber gives some data to avail services from an organization. So typically that's what the rationale for data protection is. But going to the historical context, right? So it's important to see the start of data protection as a concern. It happened, uh, you know, in the early 70s, right? I mean, what we're talking here is about data privacy. So the concern about data protection and data privacy started in early, because of that the technology of that particular era, right? So it was new for that era, to this was the first era which started to look at data. Before that, there was no data. In a digital format, all they had is paper records, paper-based data, and other stuff. And the need for sharing this information within the European Union was also very, very high, right? So the European Economic Community, as such, has to thrive. If you compare Europe, Europe is very much comparable with India, whereas European Union as such is a consortium of 28 different countries, whereas in India we are a consortium of 30 odd states together, right? So for the European economy to thrive, unless otherwise, people move between countries, their data moves between countries. All of that did not. If that was not supposed to happen, then the the economy will be very very gloomy for Europe. And to enable that, there was a need for a lot of cross-border data transfers, right? So that's one of the major concerns that why data protection wanted to be a very important topic, because some countries, uh, while some data is within the jurisdiction of a specific country, the country specific laws are going to be applicable to them, and it may kind of give a protection mechanism for the citizens. But let's say a Spanish data is crossing the boundary of Spain and going into Portugal. Now, can a Spaniard be assured that the Portuguese company or the Portuguese person who is processing the Spaniard's personal data is going to treat as if it gets treated by a fellow Spaniard or a Spanish company as such? So that raises concern. And why is it a concern for Europeans? If you trace back, before even data privacy, the why is Europe the birthplace of privacy? Why is that they are the front runners in privacy? Because they have learned their lessons in a very hard way in the past, right? If you take the World War II, the German occupation, the concentration camps, the Holocaust, all of that, if you relate, it is nothing but, one way you can say it's a human right violation. But what was the base for that human right violation is basically, if you look at today, it's a privacy violation, right? Because somebody belonged to a specific ethnicity, and that specific ethnicity details of an individual is getting disclosed, that led to the concentration camps and the Holocaust and killing of people, bringing down the whole world in terms of a world war. This is if you look at that, that's nothing but if, let's say, if somebody's identity was not to be revealed, let's say somebody is not identified as a Jew, or somebody was not identified as some other race, probably we would have not gone into a war back then, right? So that sensitive personal data of people led to bad historical consequences for us, right? So they've learned the lessons hard, and people were afraid that would I still be treated because of my data letting people know certain characteristics about me, right? So that's another concern why always that's one of the reasons why Europe, we call that as a front runner in privacy arena, because they want to get away from that space of bad historical precedents and start to protect privacy of individuals, which is a very valid concern that they have, right? So that's one of the major I would say accelerated towards privacy regimes in the European Union. Even before things like a harmonized approach across European Union came, there were many countries in its own capacity. They had data protection regulations in the 1960s and 1970s even, right? Of course, in 1970s, what also had started to happen is the computers were invented. Large enterprises starting to realize the small value that data and processing of data can fetch for those large enterprises. And when these large enterprises are banking on personal data, of course, the governments were worried that they should kind of make sure when these enterprises processes and transfers data between countries, the rights of the people are guaranteed, and those data cannot be taken for granted by any means, right? So that's the need for privacy at large in the 1970s, if you look at it. In the 1970s, we did not have the European Union as such, because European Union came into existence only later. In 1970s, you would find references to EEC, which is European Economic Community as such, right? So that's the rationale for data protection in the 1970s. Going into the foundations even before 1970s, right? So if you look at privacy, it's very, very closely entangled with human rights as such, right? So all of us know after the World War ended, the United Nations was formed, and in the United Nations General Assembly, because of war crime and other lot of misplaced people, displaced people, they getting abused and other stuff happening, there was a very imminent need for having human rights, a charter on human rights as such, just to ensure all the country to adhere to certain basic protocols and not taking human rights for granted. So the effect of that is something called as the UDHR, Universal Declaration of Human Rights, which came into existence from 10th of December 1948. So the UDHR is otherwise just called as HRD, nothing but Human Rights Declaration. So Universal Declaration of Human Rights is otherwise called as Human Rights Declaration, Basic Human Rights Declaration, right? So this UDHR was the very first stone that was laid in this whole building or whole ecosystem of privacy and data protection. European laws and standards and everything were adopted from this UDHR. So the UDHR, though it's a very broad human rights specific declaration, many of those rights that are coming under human rights were associated to the privacy of an individual concerned. More precisely, there were two articles within UDHR, article number 12, which is called as right to private and family life. That means every individual is having their right to start a family and to start a private life. So that's article 12. Article 19 is right to freedom of expression. So I can freely talk and express myself with my opinions and thought processes. Those are two important articles that UDHR gave to the world. Now, if you look at the Article 12 and Article 19, you would find a bit of a conflict introduced between these two clauses. One side, a person is entitled to start his own family, have a completely private life. On the other side, there is another guy who has got a freedom of expression, and using this freedom of expression, he potentially can poke into the affairs of another private individual using his freedom of expression. That many times happen, right? Now, there is a very fine balance required between when somebody is exercising their rights under Article 12 versus exercising their rights under Article 19. So your freedom of expression cannot poke your nose into somebody else's private life. So there has to be a balance brought in, and that balance was brought in using one more article within the UDHR, which is called as Article 29.2. Individual rights are not absolute and balance must be struck. So though human rights mentioned a lot of rights to human race as such, there was a clause that kinds of restricts and then says that, look, what rights by default, but you cannot take them for granted. While you're exercising these rights, be very cautious that you don't interfere into a conflict in nature. And these rights are not absolutely available to you all the time. And institutions can be formed to kind of bring in a balance between more than one person's rights versus freedom, these talks as such, right? So that's what the very foundation stone for privacy was the Universal Declaration of Human Rights, the human rights law as such, right? So now, if you look at as this slide explicitly says that the UDHR is the foundation for all European data protection laws and standard, we will now go into a very specific, this UDHR is an international concept. It's not specific to European Union alone. So next slide, we will slightly see how this UDHR transferred into a very European specific declaration, right? So adopting this UDHR, Europe came up with its own convention called European Convention on Human Rights, which is called this in an acronym way, ECHR, right? So in 1948, UDHR came in, and then in Council of Europe in 1950, adopted this convention or had this convention on human rights called the ECHR. The ECHR is clearly based on the UDHR because, as we said, the foundation is coming from there. This ECHR, though it was originally formed in 1950, it only came into existence or force from 1953 across all the European member states back then. So they were not 27 as we speak today, even much lesser in number, right? So those states commonly adopted the ECHR and had laws enacted to support the implementation of ECHR within their national boundaries. The convention had various different rights given to individuals. There were some which were given as very solid right, and then there were some which were being deliberated between the countries whether to give that as a very solid right versus not. For example, right to life is a very foundational and basic right that almost the Indian constitution also carries a lot of those rights as part of our fundamental rights, right? So right to life, right to freedom from torture, freedom from slavery, rights to liberty, right to a fair trial, right not to be punished for something that wasn't against the law, right to respect for family and private life, right to freedom of thought, conscience and religion, freedom of expression, freedom of assembly, which was taken away during the Corona days, right? So the government said that you really cannot, more than 4 people, 5 people in many countries in Europe were banned to gather together. That was against the freedom of assembly, according to many activists who played a major role there. Right to marry and start a family, right not to be discriminated against in respect of these rights. So these are the foundations, various rights that ECHR gave. And then there were a few more rights that were contemplated whether to be included as a basic fundamental right versus not, something like right to education, right not to be subjected to a capital punishment. These were all proposed to be included, but for various reasons they were rejected by various countries, and still they don't find a place in the convention. They are still an optional right that is available, which is granted to citizens by a few countries and not by other few countries, right? So if you look at this one, so the UDHR had 2 articles, which were Article 12, right to a private and family life. Article 19 is the freedom of expression. So both of them, which were closely associated to privacy, is also echoed under Article 8 and Article 10 of the ECHR. So Article 8 is very, very synonymous and then says the right to respect for family and private life. And Article 10 is freedom of expression, which is the same as Article 19 in the UDHR, right? So this is how ECHR kind of came into existence, being adopted from UDHR, or inheriting a lot of properties of the UDHR, right? So this human rights in the Convention on Human Rights is actually enforced by a separate court in the European Union, which is called as the European Court of Human Rights. It's in Strasbourg, and this particular court gives on human rights is going to be binding on all member states concerned. So when we say binding, that means if this court gives a judgment, interpretation of the judgment and the implications that the judgment is going to cause, all member states that sign this ECHR will have to adhere to that, what the judgment really reads out, right? So that's what we mean by binding in nature. I know it's already too much for some people, history, geography, but if you kind of link from one event to the other and remember the sequence of the event, it'll be much easier for you to remember. right? First, we started with 1948 UDHR, which is after the World War was done, United Nations General Assembly came in and then enacted that. And in 1950, the UDHR was inherited specifically in the European context, and then ECHR came in. ECHR resonates UDHR, and ECHR is enforced by another ECHR. So ECHR is enforced by ECHR. Remember that. European Convention on Human Rights is enforced by European Court of Human Rights, right? So that's more than enough for us to know from UDHR and ECHR's standpoint. So the takeaway for you here is right to private life and associated freedoms are fundamental in nature in the European Union. I'll pause here. If there are any questions, I'll be happy to take them. Anybody who's already feeling overwhelmed with the content for today? All good, guys?
Okay, Suki, I'll start.
All right.
First thing, listening to all that you had said about privacy and how the Europe, is my voice audible or is it crackly?
Absolutely. It's very good.
Okay. Listening to all that you mentioned about how Europeans are, they like their freedom, privacy, and all that. How is that? My question that came up now, even now, was, how is that, in a country like France and other European countries, the paparazzi, seems to be taking over everything, and they intrude into the private lives of people. So many cases. I mean, I mean, the whole world looks up to the French paparazzi for coming out with private lives of people, and they are the ones who are known for it. How is there is no law, or no one has any kind of a restriction put on them? I mean, don't call them as right to expression. This is completely would be under the freedom of the press, but still, they are actually intruding into the private lives of people, right?
That's right. Unfortunately, that's a fact as well, Jaral. Very good question, right? So, but if you look at the paparazzi that happens around the world, they do it mostly. It's for journalistic purposes, right? Now, even with GDPR now in place, there is an exemption granted under GDPR even for any personal data that gets processed for journalistic purposes. So people who choose to be being on that limelight, that's why I said in one of our sessions, the way that I treat privacy versus a celebrity treats privacy is very drastically different. Now, even that celebrity, if some information that they don't want to disclose, but these paparazzi is going around and then finding those kind of the gray side of people, the dark side of people, they get pissed off, and that's why they slap all these defamation case suits and other stuff, right? So that continues to happen. As long as good things comes about them in the news, they are happy, everybody is happy. The bad things comes about them in the news, nobody is happy, at least, right? So that is given as a right to those individuals to kind of protect themselves from defamations and other stuff. But journalistic purposes, generally there is an exemption granted.
So you're saying that even today, with all the privacy laws in place, with in Europe and other countries, I'm not sure about how it works in California, but still, if it is from an journalist standpoint, or newsmakers or something, then they are exempted from all these, and we cannot contest against them or win a case against them. How does it work
As
as an
long as it's
individual?
right, as long as it's factual, it's based on science and facts, you can defend that. But if it's unfactual, I think you have the right to defame. If somebody is purposefully defaming someone and all that, they can stand their right.
Okay.
Yeah. All right. Any other question, anyone? Or do you guys feel overwhelmed already for the day with 2 topics?
I'm good.
It's funny. All right, so let's slowly proceed further. I'll be very conscious that I'm not introducing a lot of complex stuffs and bouncers in one day itself. So let's go very slowly. So this is the unpaining, right? So UDHR and ECHR, you guys would be comfortable. Now from 1940s to 1950s, the first slide was a 1940 slide, 1948 to be precise. Second slide was a 1950 slide, 1950, 1953 is the years that we spoke of. Now let's bridge the gap between 1950s to 1980s. So what happened if you look at between 1960s and 80s? As I said, few countries, look at this, right? So this doesn't have, the ECHR doesn't have data protection as a fundamental right anywhere. Bits and pieces of privacy related ones are given as rights to individuals, but data protection is not a fundamental right. Nobody is saying that your data is always protected and that's a right that you have. If somebody has misused your data, then you have the rights to go and sue them in the court of law or take appropriate legal actions against them. That's never a case with the human right laws. But there were some countries which were pioneering in this space. Spain, Portugal, and Austria, Austria being one of the most affected ones by the war, had data protection as a fundamental right in their constitution. That means even if the ECHRs and other things were not emphasizing on data protection as a fundamental right, these three countries went beyond and made this as a fundamental right in their constitution, which is a great thing, right? And then 1960s is when this later 1960s and early 1970s is when this these scientific and technological advancements in the field of data started to happen. Now, in 1968, there was a recommendation put forth by a college of people. This is famously called as Recommendation 509 on human rights. What does this recommendation do is all about to speak the missing elements of scientific and technological developments and its impact on the privacy is what this recommendation was speaking. So if you look at the ECHR, which was written in 1950s, there were no very advanced thought processes given from a technology standpoint. Back then, the technologies were very limited, so they didn't bother to bring a lot of technology. Maybe they had very few technology that was relevant during those days to be counted or factored in. But with 1970s, when the advancement of technology is exploding very fast, there was a need to understand what is missing in ECHR and how do we bring the consequence that scientific and technological advancements and developments are bringing into our everyday personal life. That's what Recommendation 509. And 5 years later, after Recommendation 509 was made, in 1973 and 74, the Recommendation 509 was adopted into resolutions. So one resolution in 1973 happened, the other resolution happened in 1974. 1973 resolution made Recommendation 509 as a principle for data protection in the private sector. So the missing elements on the ECHR, the scientific and technological developments, that was adopted as a resolution and said that, hey, all private companies who are processing personal data and using advanced science and technological means to process that, you will have to probably follow these recommendations given. So that's the resolution that got passed in 1973. And 1974, the same recommendations were also enforced on public sectors and then said, hey, look, even if you're a public sector company and you're treating personal data, ensure the technologies that you put in are not really violating anybody's privacy. So this happened predominantly in the 1960s to 70s. 68, very foundational recommendation was given on the missing elements to address scientific and technological developments. 73 and 74, those recommendations were adopted into resolutions, 73 for private sector and 74 for public sector. And then we will switch on to the 1980s. 1980s is again a very, very interesting time and turnaround for privacy regulations and privacy in the privacy space in itself, right? So the very foundation of a modern day privacy regulation or a data protection regulation was laid in 1980. And that foundation was laid by somebody called, or some organization called, Organization for Economic Cooperation and Development, otherwise called as OECD. So they came up with a guideline on protecting privacy while doing cross-border flow of personal data, right? So that guidance is what is transformed into regulations across many places in the world today, right? So the guidelines, OECD, otherwise called as, famously called as OECD guidelines, many places you would have come across this word, right? So it had various principles and guidelines under it. We will study about them in I think in the next couple of slides, but that's the foundation. And again, the OECD is not a very European specific thing. So it was it was a global organization, and anybody who was party to the OECD were bound by those guidelines, are supposed to follow those guidelines. Now, what very similar to the UDHR and the ECHR concept, right? So there was something international adopted its own way from UDHR, and they created the ECHR. Very similar to that, Europe adopted or inherited a lot of things from OECD guidelines and came up with their own convention called Council of Europe Convention, otherwise called as Convention 108, which is a very, very first step within the European space in privacy. This was the very first legally binding instrument of privacy within Europe, in the space of data protection and privacy, right? So that happened in between 1960s to 1980s. Now I'm kind of summarizing it once again for you guys to keep the history intact. 48 UDHR, 50 ECHR, 60s recommendation 509, 70s resolutions 73 and 74, 80s OECD guidelines, and similarly in 80s Convention 108, or the Council of Europe's Convention on Protection of Personal Data. All right, so that's the history so far that we have traversed. Let's go into what's OECD. Let's see. Yeah, OECD is given here in detail.
Suki, I have a doubt.
Please.
Yeah. So, can you move back to the previous slide?
Yep.
Yeah. So after we had ECHR in 1950s, and then directly Spain, Portugal, and Austria, they made data protection as their fundamental rights. So between these, there were no countries to incorporate local laws for data protection.
Yeah, that's what the understanding that we're getting from looking at the history, Asta.
Okay, Suki. And one more thing, how far were these recommendations and resolutions binding on the countries? Were there any penalties or effect of this resolution for not following?
They were not binding, right? Recommendations are always recommendations. So once it was passed as a resolution, of course, the parties who signed that resolution, it was only binding on them and not every country otherwise.
So resolutions were binding on the
countries. The parties who signed the resolutions, it were binding to it, right? Not all parties eventually would have signed that resolution as well.
And these were only within EU, right?
This is only within EU, correct?
Okay, thanks, Suki.
All right. Okay, any other questions?
Yes, Suki, Niranjan here. So,
yes.
Since US is also in terms of advancement, US and Russia were also competing against each other with Europe, right? So is there any particular reason why USA and Russia did not come up with this kind of regulations, and why only Europe?
Okay, so the context that we are studying is European context. That's why we are not talking about US and Russia. But of course, there could have been a similar landscape that existed in US and Russia as well. But I'm not very, very well versed on what happened back in those days in US and Russia. But maybe if we do sometime later a course on Russian data protection or US data protection, we will get to know more about this.
Okay, sure. Understood.
Yeah.
Thank you.
No problem. All right, guys. There's so much of silence today. Is it going good? Is it bad? Is it hard to follow?
Suki, actually, there is nothing to discuss here. It's just we have to memorize this.
That is actually right. So, I mean, right. So if you are an examination taker, you just have to follow this timelines and other stuff. But if you're not specific about the examination, unless otherwise you are really a historian yourself, I wouldn't recommend you to remember all of these stuff. We will chapter 2, I mean not even chapter 2, right? So yeah, chapter 2 onwards might be a little bit of more interesting for you guys. With that said,
Suki, Niranjan here again. Will you be sharing this slides with us for our reference?
Nobody, sorry, I would not be able to share the slides with you for some reasons. I mean, I don't want to be discussing that, but if you want a read-only access to this, I can grant you, but I can't just...
Yeah, read-only access would be fine. Just that it'll be a reference for us for the exam.
That much I can do. I can do. Yeah, sure.
Yes, that is fine.
All right.
Yeah, thank you.
Suki Vani here.
Yes.
Okay, so I heard that the convention 108, the number 108 is given to that because of the number of treaties, the convention has signed. So is that recommendation 509 is also just a number, like a serial number, or is there any other significance to it?
I don't think there is going to be any significance to it. It's just some record keeper was keeping the number of recommendations that's coming in a year or something, and then they gave that number. Because typically, if you look at the resolution 73/22, it's typically a numbering, right? It's a taxonomy that they were following. In the year 1973, that resolution was the 22nd resolution or something like that.
Okay.
Very similar to that, there was an inventory that somebody was creating a register, and it could possibly be 509th recommendation that was given by somebody.
Okay.
Yeah.
Thank you.
All right, let's move on. So the OECD principles is what we will study first, and then we will go to the European specific one, which is the Convention 108, right? So unlike UDHR and ECHR, there is one important thing that you have to keep in mind. UDHR came first, ECHR came later. There was a good 5-year gap between that. But between OECD and the Council of Europe's convention, there was not much of a time gap. Both of them came in 1980s and 1981, if I'm not wrong. The reason for that is both of them worked together to co-develop these guidelines. Right? There was a lot of cooperation between OECD as a body and the Council of Europe as a body to kind of develop this OECD guidelines. And for a fact, Council of Europe was born on the 23rd of September 1980. The date is not going to be asked in the examination, but it's good if you can relate it to something, right? Now, the OECD's, the reason why OECD came up with, as you can find from the name itself, they have nothing to do with privacy. The role of OECD is more of economic cooperation and development, right? But at that juncture in 1980s, economic cooperation and development cannot happen without a free flow of data across borders. Now, that's the reason why OECD had to take up this additional work on them to come up with a guideline on how do I regulate and govern any data that is flowing between borders of one country to the other. And more importantly, if that data is personal data, how would I ensure that the protection of personal data and individual is not hampered or tampered while I kind of need transferred for economic purposes. That's the basic aim and objective with which OECD came in, right? Now, OECD guidelines, as you know, this is this is not a legally binding instrument, right? It's just a guideline. As it says, guidelines are guidelines. It's up to you to follow it versus not, right? But then this guideline actually became the basis for legislation, privacy legislations and data protection regulations in many countries that did not have a data protection regulations in the past. Since it is co-developed with the Council of Europe Convention, you will find a lot of similarities between this OECD guidelines and the Convention 108 as such. The OECD guidelines are agnostic about who is adopting it, what kind of technology the adopters are using. So it is neutral in nature, applies to all technologies, applies to all sectors, including public and private, right? So that's OECD. Now, if you go further into kind of bisecting OECD guidelines, a lot of people confuses OECD guidelines with OECD principles. That's the reason why I brought in very clearly here. OECD actually had a guide that was a 5-part guide that was created by OECD. Part 1 consists of general definitions. Part 2 consists of within a national level, what are the basic principles of application that I should bring in? So that's part 2 for me. Part 3 is basic principles of application at an international regime. So once the data is across the borders, how would I legitimize those transactions and ensure free flow of data? Part 4 consists guidelines on national implementation, and part 5 consists guidelines on international cooperation. That means how there is going to be arbitrary mechanisms put in place between two countries which are sharing information, or between two parties who are based in different countries and different jurisdictions. If there is a problem with the data, how will they cooperate between each other and mutual understanding and other stuff, right? So that's what part 5 consists of. Now, what generally people call as OECD guidelines is actually the OECD principles. Colloquially, a lot of people I've seen using the terms principles and guidelines in a synonymous way, but guidelines are that 5-part and principles are 8 principles basically. Now, where does that 8 principle actually sit in is actually these 8 principles are nothing but the basic principles for national application. So part 2, this basic principle of national application, is what you see here expanded into various 8 principles, right? These 8 principles, with that, I think we will stop for the day because we might spend a good amount of time discussing these 8 principles. And while we speak about them, you will understand why OECD has been the very fabric of almost all data protection regulations across the world today, right? So the first principle goes and talks about collection limitation principle. What does that word collection limitation mean to you guys?
Limitation of personal if possible.
Okay, probably let's do this as a brainstorming session and then try to map it back to the principle, right? Now, you are going to a supermarket to buy stuff, and that the counter guy is saying that, sir, we have a loyalty card program. It would be great if you subscribe. And when the counter guy is trying to sell a loyalty card program, of course, he's going to ask you a lot of information, personal in nature. Now, when he's asking this personal information from you, what basic information or notice that you would expect that loyalty card program guys to give you before you can disclose your data comfortably to them?
For what purpose they're going to use my data?
Super. That's nothing but your purpose specification principle, right? Purpose specification says that anytime you are processing data, you got to ensure that the consumers who are subscribing to a service, or otherwise called as a subject, a data subject who is asking for certain services, to them you should ensure the purpose for what reason why you are collecting this data should be disclosed, right? So that's what purpose specification is. Tell you are going to process their information. That's purpose limitation. Now you may slowly start to understand why OECD is the basic fabric, as I said. That's one.
Suki, at times your voice is, I'm not sure if it is just me or someone else can also vouch,
Yeah,
but
it's
we
Yeah, it's
lost.
for me as well. Even the screen is going off.
Okay.
Really?
Yeah, maybe you should switch to a lower bandwidth or something like that. I mean, maybe you can turn off the screen and then it gets better, I probably think.
Turn off the screen. Okay. Wait a minute.
If in case you're talking something, we are unable to hear.
I'm not talking at the moment. Just a minute. Generally, I get a indication of how good is my connection. Okay. I think I've adjusted my connection settings to be balanced between performance and quality. I hope this is better now.
Yep, we're able to hear you.
All right, fine. So were you able to get my question? I got one answer, but was the question clear to everybody, or do you want me to repeat the question again?
No, I think the question and your explanation also we heard. Just the later part, you were moving into with a purpose collection, and then we lost you.
Right. Okay, fine. So, we understand, right? So this is purpose specification. The principal purpose specification just says what one of our friends explained, that when you give personal information to somebody, you expect them to tell the reason why they want your information. That's specifying the purpose. That's one of the principles. Now, what else? What else do you expect from the loyalty card program, guys?
They have to collect only the details that are needed and should not ask for my bank details or something like that.
Precisely. Thanks, Niranjan. That's exactly called as collection limitation principle. That means you collect only bare minimum information that is required for you to satisfy the purpose to which you are processing the data for. Don't overdo or don't ask more information and collect only the bare minimum. Limit your collection is what collection limitation is, because today's world, data is the new asset that everybody says. At the same time, data is also the new liability, right? So if you have all the data in the world, fair enough. As long as you're not breached, you are the wealthiest person in the country or in the world. But the moment you kind of mishandle that data and other stuff, you are also going to be paying a huge liability from your pockets, right? So collect only that is very, very essential and limit that collection to only those essential part. That's the very first principle of OECD. That's called collection limitation. Super. What else?
Whatever the data that they collect, whether they are going to use it only for the purpose that they have specified, or are they going to use it for other things like marketing or any other purposes? So which is
Very good, Mani. Thank you very much. So that's nothing but your use limitation principle. That means we are saying, okay, while you collected the data from an individual, you told them that you will use the data for A, B, C purposes. Now, how would you ensure that you are actually using the data only for A, B, C purposes and you're not processing the data on top of A, B, C for X, Y, Z as well? Right? So that's exactly was use limitation. So organizations are responsible to use the data only for the purposes that they've disclosed to the users and nothing beyond and above. Again, a principle, a very foundational expectations that users will have or consumers will have, which is satisfied, which is principle in OECD. Great. What else do we expect from them? Collection limitation, purpose specification, use limitation. What else?
if I have, like, let's say I gave some details, and if I want to change it later like let's say my phone number has changed.
Right.
Would I be able to again go and correct it or not? So
Super. Very good. Thank you, Vani. So that's nothing but individual participation principle in OECD. That means I, as an individual who provided my data, I should have some control over my data. As Vani said, let's say I had a previous phone number, or let's say I was living at a different address a couple of months back, and I moved places now. Now, I want to ensure that all my correspondence related to my credit card is not still landing up at my old address, but routed to my new address properly. And for that to happen, I should go and approach the, hey, I have updated my, I gone into a new place and this is my proof. Can you please ensure that you update my new residence address in your banking system and ensure all my emails, all my mails are coming to that new address. Now, what you do here is you have your right to participate in this data transaction and then have command and control over certain aspects of your data. In new laws today, we call this as one of data subject rights, which is right to access and rectification. So the entire family of data subject rights that is there in GDPR and other bills are equated to your individual participation rights. So as in OECD principles terminology, right? So that's individual participation. Thank you, Vani. What else?
Hi, Suki.
Yeah, go on.
Yeah, I think to have adequate security.
Absolutely. Thank you. So you cannot achieve privacy and data protection without having security controls. That have been the discussion of our day 2. And that's precisely what our fellow also says here. So security safeguard principles is nothing but saying have appropriate technical and organizational measures to ensure the security of the data is not disturbed, is not taken for granted. It's not, it's basically the data is safe. Ensure that. That's what security safeguard principles are. What else?
Data quality.
Can you explain that? What do you mean by data quality and why is it related to privacy?
See, whatever data we are actually collecting or using, it should.
Hey, not sure. Was it me? Because I can't hear anything.
I think we lost her.
Am I audible? Is it a connection at my end or is it her?
No. It was just her.
All right, okay. We'll wait for her to come back. But anybody else want to try why data quality is a privacy or a data protection problem?
That's okay. Whatever data the organization is storing or collecting, that should be updated.
Yeah, that's right. But why is that a data privacy problem or a data protection problem?
Can I go now?
Let the organization have garbage. I don't mind. It's not my problem, right?
But what
Suki, I guess.
But what if, like, for example, it's the address. I don't live there anymore. Someone else lives there. So then it will.
Great.
Then
Thank
it happens that person's privacy.
You got the answer, right? So, a garbage information, if it points to me, instead of my right information, you have a wrong information, my privacy can be compromised because of the wrong information. Let's say a bank is sending my, as Asta gave that example, my credit card statements to a wrong address. Now, the wrong address, a recipient of the wrong address can receive and then start looking at my spending patterns, my name, my card number, and other details, which I would not be comfortable with. And with that, potential my private life, right? So that's why quality of data is also related to privacy of individuals. Some people think that data quality is a data governance problem and it's not a security problem or a privacy problem, but it is definitely not the case. Quality data only ensures privacy and security. If you have no quality data, You have other problems like overheads in the systems and other stuff, but of course you also have problems related to security and privacy as well. Great, thank you. So that's nothing but your data quality principle as such. So we've covered collection limitation, we've covered data quality, we've covered purpose specification, use limitation, security safeguards, individual participation. We do have two more principles in OECD, but we have still not covered enough of what expectations do we have from this loyalty card, guys.
Liability.
Accountability. Accountability.
Accountability.
Accountability. Can you explain what you mean by accountability?
So they're held responsible.
Yeah.
Oh yeah, I'm sorry. Yeah.
I think if somebody is collecting the data, then they're accountable for the use and misuse of it.
Right. But
so basically, I trust my data with you, and I want you to be held accountable that you protect it as much as I want you to keep it safe.
Very good. Okay, fine. Both of you are spot on. Harish, go ahead.
Yeah, I was going to say the same. Yeah, if they are handling my data, I would expect them to take care of it and not leak it or misuse it. So I will. Then they should be accountable for my data.
Super, very good. So basically, you would expect them to have the right set of policies, procedures, protocols to be followed when they handle my personal data.
Correct.
Right? So that's what accountability is. Great, super.
Does this also include confidentiality? I mean, is it related to accountability? As in, they shouldn't be sharing it with unauthorized persons. And
yeah, that's part of your security as well as accountability requirements.
Okay.
Right, so that we got another principle covered, which is accountability. Now there is only one that is pending: openness principle. Right?
Yes.
Anybody so take a stab?
About transparency.
Yeah. Okay. Transparency. Can you elaborate further? What do we mean by transparency?
As in what the controller or the processor will do once it processes the data. I mean, what is the it's something on lines of purpose specification, but it's being transparent to the user. I mean, to the person whose data is being collected.
Very good. Okay, fine. So somebody else was trying to speak. Astha, you wanted to go?
Yeah, almost the same thing, that the person or organization, whoever is collecting the data, he or she has to be very open, completely open about how my data is going to be collected, processed, for what purpose it is going to be used, how it is going to be deleted. So everything that is going to be done with my data, the person has to be open about it.
Very good. Okay. I think somebody else also wanted to add something to it.
Thought was, in case the controller or the person who's holding my data loses it, or something has happened to my data, I want them to be open about it and communicate to me, so that I, and as well as the controller, can take a joint action to see that my data is then secured, or some corrective action is taken. So I want them to openly come up and tell me without hiding the facts.
Absolutely. Thank you, Gerald. So openness is actually branches out into two things, right? One, being open at the time of collection of data with all the answers to the WH questions that Astha was asking. But that's not the end of openness. Openness should also be throughout the processing and even beyond the processing as well, right? So you rightly pointed, if something goes wrong with my data, again, there is the need for openness from the organization standpoint to let me know that, hey, look, buddy, your data has been breached already, right? So yeah, and these are the remedial measures that you can take now. So that's also openness. Thank you very much for both all of you guys to pinch in, right? So that is precisely what openness principle is, right? Now we've discussed all of these principles, the 8 principles that is listed under OECD principles. Can you imagine any other thing which is not covered under these 8 principles as an expectation as a consumer that you may have from the businesses?
Yes, Suki. Here we are talking about accountability, but how about who is responsible
for
handling my data, or basically who? Accountability is covered here, but how about the responsibility? Who is
So
responsible?
okay, let's take this question in a different way. You just okay. There are two guys. You have a task to be performed. There are two guys. One guy is responsible for the task, and the other guy is accountable for the task. Now, if you are an external party coming and asking questions to this about this task, who would you end of the day will hold in question for a completion of that task? Would you ask the responsible guy, or would you ask the accountable guy?
Accountable guy.
Yeah, accountable guy. Yeah.
So accountability supersedes responsibility.
Okay.
All right.
Yeah. Got it.
Yeah.
See, under principles, I would think I would like to have one more in the sense, immediate thought. What if my, the thought process, or even I want to change? First, I had given my consent. I had, agreed to go with, thing, and then at a later point of time, for some other reasons, I do not want to continue, or I just want them to forget about my information or not hold my information any longer. So, is there a principle for it?
Individual participation. You participate in that whole journey and then take control of the data whenever you want.
Right, but does it also include the right to be forgotten as well as
the principles are foundational nature, right? So how do you adopt those principles into various regulations? Again, is going to be basis a lot of different context. Which country, what is the era that we're talking about, what's the technological advancement of that era, all of that factored in. You can play around with this individual participation. And with GDPR is also based on all of these 8 principles, right? Now the 8 is condensed into 6 or 7 in GDPR, but your data subject rights is nothing but an inheritance from individual participation principle. Now GDPR adopted the individual participation principle to an extent. It is applicable and practicable, and practicable in today's environment. And that's why they came up with right to withdraw consent, right to object to processing, right to say no to automated processing. All of that came, but that's also all of them come under the overall umbrella of individual participation principle.
Sure. Okay.
I have a question.
Okay. Hi.
Can I go? Sorry. Oh yeah. Okay. So my question is, say for instance, the purpose of the collection is to generate more data. Then to what extent will you be like, say for instance, like social media? So using some amount of data, they're generating more data, right? So like, to what extent will you be generating data if it's revolving around you?
No. Ask the question again.
I mean, like for instance, you're using social media. Then you're giving only some amount of data, but they're actually generating a lot of, by connecting a lot of other factors, they're generating more data about you. Then to what extent will you be doing that? To
what extent will you
be generating the data? I mean, like to a certain extent, they can know about you, right? Like about the details, but there is other depth also. Like, I mean, I'm not sure how to put this.
Yeah, what you're meaning is about indirect data collection, data harvesting, and other stuff.
Yeah, correct. To what extent will they be doing this? They can do it for a long time, and the depth can be really deep. Right?
You really cannot control, right? It depends upon the capabilities and the reasons that why they are doing. For example, if you talk about Cambridge Analytica, I'm sure you would have heard about Cambridge Analytica, which had right. So they came on record and then said, about every American who is eligible to vote, I have 5,000 data points about them. Right now, these 5,000 data points, of course, the users would have not directly given all these data to Facebook companies or Cambridge Analytica as a company and all, but they were able to connect the dots, and then there is no stoppage to it, right? You can keep going on and on and on, right? So there's nobody going to be saying that this is the limit that you should do, this is not a limit that you should do. That's why the law is also there to protect the rights. If something goes wrong in this, but let's say if Cambridge Analytica is doing all of that, not keeping in mind any of these 8 principles, then you can potentially call what Cambridge Analytica is doing is an unlawful processing.
Correct.
right? So, but no law will say that this is what you can do, this is what you cannot do, looking at a specific process as such. The law is going to be very generic in nature, that it can embrace as much, scenarios as possible within it.
Correct. I get it.
Yeah.
Oh, thank you.
Hi Suki, Pritesh here again. So I'm just wanted to know, is consent a part of this principle?
Consent is again part of individual participation, right? So when you consent, you are participating actively and then providing your consent.
Right.
Right? Yeah.
Suki, questions like where will my data be stored or how long are you going to keep it? So will they be part of openness principle?
Absolutely.
Okay.
So take it as a homework for you guys. Think of any question that you may want to know an answer for before disclosing your information to a user, to an organization, and come back tomorrow. We will find if that question is covered by the privacy principles of OECD versus not. Right? I think with that we will stop for today. There's too much, but I think towards the end, with the OECD coming in, it became a bit more lively. Before, when we were discussing UDHRs and ECHRs. So with that, we will close today's meeting, and we will come back tomorrow. Once again, revising OECD guidelines and moving on to Convention 108 and how those OECD guidelines go hand in hand, or the similarities between OECD guidelines and Convention 108. And from there, we will take it forward. Thank you, everyone. If there are any questions, please stay back and ask them. Otherwise, feel free to drop off. Good night. People in Chennai and Tamil Nadu, please stay safe. Looks like the rains have started already. So just stay home and take care of things. Thank you.
Thank you, sir.
Thank you, Suki.
Thank you, Suki.
Suki, one doubt. What is the difference between collection limitation and use limitation, which you said?
Is going to be talking about during the time of collection, you collecting only the bare minimum information. Use limitation is going to be talking about you are using the collected data only for specified reasons and nothing beyond and above.
Okay, thanks.
Yeah.
Suki, yesterday you mentioned about Google collecting information for a very long time, and you yourself were, wondering that how much of data they know about you. I'm just wondering if there is anything that as an individual that I can write to Google and say I want the right to be forgotten, or not to hold my information over this period of time or something. Is there any provision for it?
Yeah, Google provides this option as a privacy default setting, right? So you don't really have to write to Google, but you have the control today. If you want to delete all the history from Google, you can just do that by a click of a button.
Okay, so it is there, though it has been collected. If I choose to go ahead and do that, it is a possibility today.
It is definitely there, but it is not just straightforward. They just don't put this button in front of everybody's eyes and then say go ahead and delete it.
Correct.
So you have to really navigate a little to find where these options are. And the second thing is, even if you do that, right? So many a times we say no to personalization, even Facebook and Google and all these places. Now, if you look at the implication of saying no to personalization, no to data collection about you, these guys are not going to stop or limit the number of advertisements or things that comes your way. It will still be, let's say Facebook was showing 10 different ads to you on a daily basis. Even after you saying no to your personalization, Facebook will still continue to show 10 ads to you. But what will happen is that 10 ads earlier, it was at least somewhat relevant to you. Now the relevance is completely gone. Then they will start to show purely random advertisements to you, which you may or may not like.
Right. Okay.
Yeah.
Suki Vani here.
Yeah. Sorry, Vani. I forgot about your question. I'm just just looking at the signal like group. I got remembered about your question.
Okay. Do you want me to repeat the question?
Have a note of that question. We will. I will let you repeat the question tomorrow during and then we can discuss that.
Okay, I have one question about today's session. So, when we say fair processing, so is that covered by any of these principles in OECD that we discussed?
All of these relate to fair processing.
Okay.
Right? Even if one of them is not in line or there is no check against even one of these principles, then that becomes an unlawful or unfair processing activity.
Okay. Okay.
Yeah. All right. Thank you. I enjoyed today's session, and we will speak tomorrow again. If there are no questions, please feel free to drop off. Thank you, guys. Bye.